realize that justice can be questionable when in family court. Litigants discover this too late at the exit poll at your bank. There are limitless and sometimes aimless laws that apply to you that have no cause and effect to your lives as you knew them to be, and they can affect you forever. There's no warning label on your court order, no place to run to get away from that which will not fit your existence, and you have no idea that you will lose all or most of your financial resources when the courts are done with you. So, I have with me to discuss this topic Robert Del Cole, who's a criminal and matrimonial lawyer, and hopefully today we'll talk about some of those things that can advance our cause or that might bring to our attention the constitutional aspects of a divorce in court. All right, Bob, here we go. Let's talk about the truth in family courts. What is it that you think is our biggest problem in family court?
The biggest problem, I think, in family court is the lack or inability of the system to cull out genuine applications for orders of protection from those that are just litigation tactics being used in a matrimonial action. The courts don't seem to have a system in place that provides someone subject to an order of protection that was issued ex parte, they call it, which is with only one party present in court, doesn't provide them an opportunity to get before a judge or a magistrate and quickly resolve the issue.
On its face, that's not fair at all, is it?
It's patently unconstitutional in my mind.
Okay.
Constitution is very, very clear. When the government, which is a court order, transgresses someone's constitutional rights in any way, for instance, in the instance of an order of protection, barring them from going to their own home or seeing their own children, there has to be a process in place that provides that person a meaningful opportunity to be heard within a reasonable period of time. I have seen case after case after case where an individual is removed from his home, barred from seeing his children, and can't get before a judge for 6 months. That is a patently unconstitutional process.
Is it possible at all, to your knowledge, that we can address that issue of the order of protection before we address any other issues like in custody, for instance?
One of the things that I find effective in my practice is to instantaneously dig your heels in. The first time you're brought before a magistrate on an order of protection, you have to assert your innocence and be ready to, on very fast notice, go to trial. If you engage in the waltz that happens up at family court, which is take a date, discuss it with your lawyer, come back in a month, time leaks away.
Yeah, I'm on the litigant side going, when's he going to call me? If I call him, is it going to cost me? I mean, there's all kinds of other contingencies that the litigant faces.
Absolutely. There is, and one of the things that I think that needs to be addressed is there's got to be some consequence imposed upon a party who walks into court and makes a false allegation that ends up costing someone time with their kids that you'll never get back, and time that the money they spent on their lawyer.
Isn't that a failure to prosecute perjury?
Absolutely. I was discussing with someone earlier today that if on 5 occasions in any given year, the district attorney or a family court judge who concluded that a perjurious statement was made under oath referred the case to the DA's office, and the DA actually prosecuted that party for perjury 5 times in a given year, it'd be the front page of Newsday every time.
And I've never seen it.
Never. I've had cases where the most blatant instances of perjury were committed, and everybody shrugs their shoulders and they'll tell you, it's family court, everybody lies.
What do you think? I mean, there's a lot of weight on a non-decision, if you will, from family court because an order of protection got in the way. That weight is carried.
The impact of an order of protection is widespread. Preliminarily, if there is a matrimonial action going on in the Supreme Court, the mere presence of an order of protection being issued at some point in time during the continuum of litigation tends to put the brakes on the Supreme Court action until the family court OP is resolved. More and more, I am seeing applications being made to the Supreme Court to pull the order of protection away from the family court so it's quickly litigated in Supreme Court. That is a nuance that is just beginning to catch on.
How did that happen? Because my experience of years of looking at this, I've never seen that.
A couple of innovative lawyers, one of them being myself, found provisions within the statutes that allowed a merger between family court and Supreme Court. One of the big developments is in Suffolk County and Nassau County is the integrated domestic violence part. So if you have a matrimonial action going, and during the course of it there's an order of protection issued at a family court or an arrest made and a charge brought in criminal court, you can make a motion to the IDV judge to have your case criminal,
go through that
integrated
IDV?
domestic violence part.
Okay.
You can make application to have not only the criminal court case brought over to the Supreme Court, but your family court case. That brings it all under one roof, and it tends to streamline things because the IDV judge tends to be a criminal court judge. So he understands, okay, let's get through the criminal, get through the family.
It is a criminal matter that's not being dealt with in family court,
well,
as it exists now.
The way the system's designed is, in order to go into family court and get an order of protection that would bar someone from exercising their rights of visitation or to go to their home, you have to allege one of the 5 enumerated family offenses. Very simply, they are crimes pulled from the penal law, wedged into Section 812 of the Family Court Act, and there's a list. The most common ones you see are aggravated harassment and harassment. He slapped me, she punched me, she menaced me, he threw me down a flight of stairs. Really not serious felony level offenses, but misdemeanor level offenses or even violations. That gets you in the door in family court, merely alleging those facts to exist, gets you into family court. Judge hears one side of the story because the other party's at work, innocent, not knowing what's going on. The other party's in there telling their story, and before you know it, a stay-away order is issued and you're served by the sheriffs. Complete shock. You don't even know what happened that day. There you go.
You know,
Curbside.
what happens to me every now and then is, because I've been doing this for such a long
Right.
time, I hear people tell me afterward, mostly females, that I have to say this is the truth, okay? We're
Okay.
talking about bringing the truth to the table.
Right, I agree with you.
That many lawyers are advancing that the wife fake abuse,
Absolutely.
feign abuse.
Absolutely, there is no doubt about it. You want to talk about the truth? There are games that men play, and there are games that women play. Most men are not going to go to family court and admit or even tell anybody that they're afraid of their wife who's half their size. It just, the paradigm doesn't fit. Nobody's going to buy it, and they're embarrassed.
My first mediation was like that.
So it's a rare occasion that you'll see a husband going into court and fabricating or even telling the truth. On the other hand, females are sponsored by their lawyers. I mean, I have put in motion papers in Supreme Court. I call it the Nassau County paradigm. It was invented by a couple of lawyers out of Nassau County. You go into family court, you go into family court, you get your refrain from order of protection, which is an order of protection that permits you to be around your house and your children, but tells you to avoid doing certain things. The next day, a matrimonial action is commenced, and within a week after that, the wife makes an allegation that the order of protection was violated, and a criminal allegation of contempt is lodged. There comes your stay-away order of protection, and the husband is removed from the house without the fuss and muss of a pendente lite exclusive occupancy application. I have seen that so many times. It's pathetic. There should be a rule against it.
Yeah, I know.
Staged.
Let's talk about just bringing in a little bit more of the constitutionality aspects. What are we missing here? What can we provide information-wise that the public needs to know constitutionally is not being met by the family courts?
There are 2 areas that I feel the Constitution is being trammeled by the family court. The first is an ex parte order is an order issued by a judge based on the story told by one side. In this case, 95% of the orders of protection issued in the family court are based upon a litigant walking in, telling a story to a judge, the judge believing them or assuming what they're saying is true, without it being tested by an adversary, and issuing a court order that removes someone from the house.
Excuse me one second. Because you can't tell at that point, the judge I'm talking about, whether that's true or not.
Correct.
If you're the judge,
You're erring
how
on
are
the
you
side
going
of
to?
caution.
Yeah, that's right.
But here's the problem. Here's where it becomes unconstitutional. I understand that. What makes it unconstitutional is there is no provision that says, as a matter of law or statute, that that person who's being removed has the right to appear before a magistrate within a defined period of time and contest the allegation, have a hearing,
Well,
get his day
we
in
certainly
court.
should. You said you've seen that before. You said it's recent. It's a recent change.
Recently, you're seeing judges Well, no, they understand you're allowed to have a hearing, but what's happening is, for years this has been the case, the courts are congested, and the person who is subjected to this order, which is depriving them of constitutional right, is forced to wait until everybody is ready for trial. In family court, that could mean 4 to 6 months. So for 4 to 6 months, someone's rights are violated and they haven't had their day in court.
That seems very clear to me.
And it's patently unconstitutional. I am waiting for the right case to come along where...
And we do that because we're a case law state.
Right. I am waiting for the right set of facts to walk in my office that I can bring an action in either federal or state court declaring parts of these statutes unconstitutional because they do not provide one subject to the force and effect of an order an opportunity to be heard in a reasonable period of time. It's a very simple answer,
sure,
but it seems to be escaping everyone for the last 35 years.
And which amendment is that? You said it before.
Well,
that's
in this here, this would be a product of constitutional law.
Sixth Amendment speedy trial, right?
Well, in family court, it would be more a case law where the Supreme Court of the United States has said the right to parent and the right to property are fundamental constitutional rights inherent in our society.
Right.
When you get into criminal court, you're talking more the 4th, 5th, and 6th Amendments.
I see.
Click in. Family court, there is no criminal prosecution. See, here's the difference. In criminal court, your penalty is jail. Family court is they just take your kids away from you.
That's what. That's what I was wondering. You know, how are we going to tie in the Constitution? They obviously don't have constitutional rights at that point. How can we claim that there's no constitutional right in the middle of this process?
The statute itself does not provide any remedy for a person being subjected to these orders of protection. So,
what statute?
Section 812 of the Family Court Act, which is the right to petition the court for an order of protection alleging a family offense.
For the OP aspect, okay.
Right.
Okay.
So in criminal court, you have all kinds of people are, at least to some extent, concerned about your constitutional rights because the bottom line in criminal court is jail or probation. So the criminal procedure law, even though it is defective on its face, because in a criminal case, the order of protection is issued as a condition of bail. So the statute regarding bail is also silent on the issue of the order of protection. Understand this, bail is to ensure a person's return to court. That's it. It's the only reason bail exists.
Right. Well, we spoke before. Didn't you say something about an element of, I recall you saying something about an element of the bail form?
What they've done is they folded in orders of protection as being a condition of bail. So, but even there, it's almost like preventative detention. It's stopping a person from seeing their children or going to their home based on the allegations of one side. Now, what distinguishes the family court and criminal court is there is an arraignment process in criminal court. You are brought before a magistrate, plead not guilty, and you have an opportunity right then and there to argue against an order of protection. The problem I have is, and I tell people this all the time, the first time I'm meeting my client is usually with his hands cuffed behind his back at the rail, and his first question to me is, who are you? I don't know him, he don't know me, I'm looking just to get him out of jail. So the real issue or the consequences of an order of protection are lost at that moment because your real concern as a criminal defense lawyer is getting your client out.
Yeah, right.
So
what existed before you got there, you need to know in a hurry, and if you don't know it, it's just get him out.
It's just get him out.
Yeah, right.
So what you're seeing now, and I actually sued one particular judge and the county and the state because a judge made believing my arguments at arraignment, the judge made the order of protection have a 5-day lifespan, meaning the order of protection issued at the arraignment expired 5 days later. And when I went back to court, I said to the new judge that had the case, because there's a different judge at arraignment.
Never heard of that.
I want a hearing now, because now you're going to issue a new order of protection I'm allowed to be heard. Judge denied me a hearing, issued the OP, and I sued her. I brought in Article 78, and much to my chagrin, the Court of Appeals didn't want to take that issue up at that point.
You had to go all the way to the Court of Appeals to get...
to the New York Court of Appeals, and they did
just to get an Article 78 proceeding underway.
Just to get a hearing on an order of protection.
Right, which was the purpose of that.
Unbelievable.
It's terrible.
Unbelievable. I had to civilly sue, and the ironic thing about it is, by the time we got all the way up to making our application to the Court of Appeals, I had made a motion back down to the criminal court judge, and they modified the order of protection to the extent that it was a refrain from Ultimately, I went to trial on that case, and the man was found not guilty, and the order of protection was vacated.
We have an awful lot of rights that are denied in family court, and I'm trying to get to the place where I can understand where our program title is The Constitutional Collapse of Family Rights, of Issues of Family. We can adjust
Your right to
it.
parent.
Yeah,
They,
the right
ex
to parent.
parte, they can, with the wave of a wand or the stroke of a pen.
Is that parents patriarch? Does that sound right? What is that?
Yes.
Okay.
That's that. You're in the right
Okay.
neighborhood. Essentially, there is an inherent right to parent your own children, and the government is the last person that should be involved
Right.
in affecting anything you do with respect to the relationship you have with your children. The problem you have is you have such a sense of political correctness that anyone literally walking into a family court magistrate and telling a story, whether it even appears to be true or not, is most likely they're not going to walk out, if they're going to walk out with an order of protection. And that leaves the person subject to that completely twisting in the wind. You want to talk about violating someone's rights? They don't even do that in Russia.
Yeah, like I said in the opening of the program, you may remember, but you don't. There's no warning label on anything that you step into in court. So rights become the scale of justice for us all. We come in thinking that there's going to be a balance of fairness, and we're going to get our heard at least.
You know, it's difficult to assess. There are certain judges up in Suffolk County that are getting sick and tired of people coming in making up stories, and they are throwing the OPs out.
Did you know in 1997 there were, the number was ridiculous, 91 or 92% false allegation rate or
Absolutely.
unconvictable rate? I forget what the term is they use. I don't remember the term.
You want to get rid of an order, the fastest way to get rid of an order of protection, in my estimation, is when I look the other lawyer dead in the eye and I say, I'm trying this case. Most of the time what they try to do is acquiesce or knuckle the husband under into signing a consent. They'll make them all kinds of lip service promises. Look, it won't be used against you. There's no admission of wrongdoing. It just ends the prosecution. That is the biggest mistake anyone can make. If you're falsely accused, you dig your heels in and you fight.
We have been recommending that for quite a while because it just made sense to us, but we didn't really have very many people to walk the path with us.
I will not, look, I've been doing criminal defense litigation for 25 years. There is not a case on the planet that I wouldn't take if a man is innocent, truly innocent, or the evidence was obtained in violation of his rights, that I wouldn't go to trial on.
Well, in the beginning when you first are trying to do this, you may not know all of that.
Right, it takes years to learn. It takes years to learn the difference between a case that needs to be tried and a case that doesn't. And it's important I tell my clients the first thing, don't ever lie to your lawyer. Tell them the truth.
Sure.
Tell them exactly what happened. I'm the arbiter. I tell most criminal clients, don't tell me what happened. Tell me what they say happened. Because most of the time, if they step out of that first person, they're able to give you a more honest, accurate depiction of what went on.
And they're also going to they've heard that side of the argument, how people have complained about what they stand on, so they might not be able to tell you that right away. You know, why should I give you the enemy's information?
The biggest thing about this whole scenario is you have usually brewing matrimonial strife, and you see the family court system just being used as a weapon time after time after time. And somebody should be putting their foot down and saying, you're abusing the system and you're going to pay a price for it. That needs to happen.
Boy, you're not kidding. Let me ask you a question. Don't judges take an oath to defend, is it defending the law, defending the Constitution?
Defend the Constitution. Yes, they do.
They take an oath, generally speaking, that's what they do, right?
Yes.
So when you know that, excuse me 1 second, I'm sorry. When you know that that's where they are, how do they defend their own actions by avoiding the criminal aspects, even if it isn't a matrimonial case?
Well, let's put it this way. There becomes jurisdictional issues. The best thing I can point to is the one time a criminal court judge, in my view, in this context, violated my client's rights. I sued her. I mean, went through the courthouse like wildfire. People thought I was nuts. But you know what? What she was doing was, in my view, unconstitutional, and there's one way to deal with it, and that's in court. So I pulled the issue forward.
And you're only doing what you're supposed to be doing, defending your client in the best
and
way that you know how.
I take the same oath as a judge when I became a lawyer.
Right.
I defend the Constitution as well. And the funny thing about it is, after I filed that lawsuit, they actually changed the form in district court, criminal court, to read that when a person has an order of protection, the order of protection is subject to rights of visitation. That didn't used to exist.
No, that's great.
They changed
That's great.
One judge who heard the case.
You're telling me in a way, though, by hearing this, and I'm telling you, I'm hearing it for the first time, okay? I'm doing this for a long time. You're telling me basically that others aren't. That disturbs me.
No,
because John Q. Public out there, who's watching this program for information, is wondering if their cousin, who's a lawyer who does contract law in Manhattan, should be able to do their legal aspect to their divorce inexpensively because they know each other. Now they have to address this. Would they even know that?
I would tell you this: you don't go to a foot surgeon to have brain surgery. I mean, you go to someone who knows what they're doing. The world.
We recommend that too.
The world of criminal defense and matrimonial litigation are twins. They're akin to each other in so many different ways. And at this juncture, in the way our court system is developed over the years and evolved, or devolved in some instances, these two worlds have merged. And in recognition of that, you have a court called the IDV court. You didn't have that 5 years ago. It's brand new.
I was going to say I never heard of it.
It's brand new.
I want to say what
and
that
it's
is
got
again.
its bugs.
Domestic violence.
Integrated
domestic violence.
And it's when you have a MAT, a family court offense, a family offense petition, and a criminal case.
Didn't we set up that,
even
when you
felonies.
think about, to me it looks like it was set up for that to happen, because the amount of laws that were against men with the orders of protection forced the domestic violence people to be on top of everything. You see them sitting at the police stations with nothing to do. I hate to say this, but there's not as much domestic violence out there as there claimed to be.
Genuine,
I'm sorry. Right. So what I'm saying is that when people make this allegation, it should be obvious to everybody that it has to be dealt with.
Absolutely.
That part has to be dealt with.
Absolutely. I think the biggest thing that needs to be addressed is what do you do with someone who makes a false allegation so they can use it as a weapon in another proceeding? People have to sue for abusive process and malicious prosecution.
Perjury, prosecute.
Absolutely.
For perjury.
There has to be, and it should be a form they sign when they go into court. Instead of just putting your hand up and saying, do you swear what you're saying is the truth? They should be forced to sign an acknowledgement that if they are found to be telling a lie, they will be prosecuted. Almost an admission of guilt before it goes forward. You watch how many people won't put their pen on that paper.
I'm wondering, yeah. Well, we're certainly going to recommend, people who help us out in this area, but I'm still alerted for John Q. Public to not be completely aware that when they get to a case that they have to address, maybe this allegation issue, let's use that for as an example, that they may have to be in two different courts.
Absolutely. 3. Supreme Court, they may be in criminal court, but that's where the lawyer's got to try to charge.
Isn't that a lot to ask somebody who maybe makes $40,000 a year and
that's why
a family of 3? I'm trying to speak out loud for them, you know what I'm saying?
This is why the attorney in charge has to push hard to get that case into the IDV parts, because then you only go to court once for all 3. All 3 dockets would appear on the same day. You're in and out in an hour and a half.
I never really heard of that, but I'm going to look into that now.
You have Judge Krecker presiding it in Suffolk County. He's a wonderful judge, former county court judge, has a heavy felony background, knows the difference.
I spoke at his hearing. I spoke at the hearing that he had about 10 years ago, I guess. Maybe
He did.
More than that.
He has done.
He's been around a while.
He's experienced. He knows the difference between somebody who's coming in and making stories up and somebody who's coming in and has been physically abused or had a crime committed against them. There's the difference. I mean, the family offense is straight from the penal law. Was there a crime committed? Very simply, that's the question. What makes me a little bit different and what separates me from MAT lawyers is the experience I have in criminal defense. I know how to pick apart a factual story. I've been cross-examining witnesses for 25 years. I've got 40 felony trials under my belt. So when you can have that kind of experience on the facts of what happened on a particular date, time, and place, that's how you beat orders of protection that are not being truthfully advanced.
We were told that the calendar was so full that they couldn't spend any time on these issues.
You know, I have had, most of the time it's not the court, it's the lawyers. I got to be honest with you. I'm not about throwing lawyers under the bus, but sometimes it has to be said. It's inconvenient for the lawyer. They have too many things going on. They don't know what, they don't understand the priority. Their priorities are mixed up. They don't understand that what's important here is to protect someone's constitutional rights. It's not just an OP. There's a consequence here on a citizen and on our country.
That's what I don't understand. The reality of the people left in the fray are families busted, children without usually fathers, sometimes mothers, dysfunction in the teen years, primarily because the father's missing.
Right.
They need the father discipline in the family. We're just dividing everything up, it looks to me, the outsider, and just collecting what's available financially out of the demise of the family.
Look, there's no worse habit than litigation. You can't gamble yourself into debt faster than you can litigate yourself into debt.
That's right. Thank you very much. Yeah.
You have to. I mean, there ain't a habit out there that'll wipe you out faster than a lawsuit.
Yeah.
My advice to people is be very cautious on who you pick. Lawyers are conflicted. They want to charge money, and they do it at the expense of their own clients, and it's a horrible,
Sure, and it's
horrible
a
scenario.
bad place for you guys to be in, for lawyers to be in, because you have to make these decisions up front. You get to know somebody for a minute, and here you are in the middle of, in business, trying to protect your client, knowing what you're at for, and also how that's going to transpire.
Difficult scenario to deal
Robert
with.
Del Cole, thank you very much for your time. I appreciate that.
Thank you for having me.
My pleasure. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.